So good afternoon, everyone. Thank you all for joining us today for our first estate planning workshop. Before we get started, just a couple housekeeping items. Today's workshop is being recorded and can be viewed again on our YouTube channel. Please remember to keep yourself muted during the presentation. And after the presentation, we will have some Q&A. So please use the chat feature at the bottom of your screen to ask questions, and we will address those at the end. So with that, I think we're ready to get started. I'll pass it to you, Dr. Lindsay, President, to open the workshop.
Thanks very much, Angela, and welcome everyone. Thanks for joining us this afternoon for this presentation, which is in honor of National Estate Planning Week. We're partnering with John G. Ullman Associates, and we have a special guest today who's going to be walking us through the basics of estate planning. I should note that the relationship between Mr. Ullman and the college goes way back. Mr. Ullman was an adjunct professor here some 40 years ago, and he has told me some interesting stories from those days. But today we're delighted to welcome Pete Winnett, Certified Financial Planner, who is a Senior Vice President with John G. Ullman Associates. He's going to be spending about 20 or 30 minutes sharing some tips on how to organize your estate, saving you time, how to protect your assets, and helping you to establish your legacy. And so after that 20 or 30 minutes, we'll open it up for a Q&A session, and you can submit questions to Pete. So, Pete, thanks for joining us and welcome.
Well, Dr. Lindsay, thanks for the introduction. And as I was waiting for this to begin, it kind of dawned on me that something I think all of us participating today have in common, probably two things. One is an affinity for Elmira College. And number two is we probably all need an estate plan. So it's a good thing that there is a National Estate Planning Week to draw attention, I think, to what's an often overlooked chore that we need to get done. It's important, and I'm gonna have to start off with a little housekeeping myself, much like Angela did. So I need to read to you a disclosure and tell you a little bit about our firm. So as it says here, we've been in existence now for 45 years. We just had a wonderful anniversary celebration a few weeks back. We're a full service financial planning firm that deals with people not only in the 44 states mentioned, but frankly around the world. All right here from our offices in Horseheads and in Corning. By full service, we have a holistic approach. We have relationships, deep relationships with our clients. So we find out a lot about them. We're in an ideal position to do things like estate planning because we know a lot about their life situations. I'm going to read you a disclaimer that we need to read for compliance reasons, so bear with me while I do this. The information discussed in this presentation is current as of the date noted, which is today, and is for informational purposes only. It does not intend to address the financial objectives, situation, or specific needs of any individual investor. Any information is for illustrative purposes only and is not intended to serve as investment, tax, or legal advice, since the availability and effectiveness of any strategy is dependent upon your individual facts and circumstances. Results will vary, and no suggestion is made about how any specific solution or strategy will perform in reality. I wanted to start with a couple stories. Both of these, I've changed the names, but both of them are ones that I've had actual situations that are similar to what I'm going to describe to you. So I have two. I kind of wrote these out last night, and I don't want to miss relevant facts, so I'm going to read this pretty much to you. The first one I'm going to call no planning, and the second one I titled poor execution. So let me start with the no planning. Again, these are situations that I have dealt with here professionally. And it starts with this one. As a young child, Maurice spent less than $5 to buy an item, essentially a toy, related to a then brand new action figure that would go on to become an American icon. Maurice maintained and protected the item with pride throughout his entire life. In his 80s, Maurice, knowing that the item had considerable value, but really not knowing how much value, decided he wanted to give that to his 3 children with the intent that they would sell it and split up the proceeds. It was a way for Maurice to help them financially. Before the children had a chance to sell that item, Maurice died. Now, because that item was gifted to Maurice, by Maurice to his children, when it came time to sell that item, the cost of the item for determining how much gain would be subject to taxation was the same cost Maurice had paid for it, less than $5. The item was sold by a renowned auction house for about $3 million, resulting in a $3 million capital gain at the capital gains tax rate that applies to collectibles of 28%, plus there would have been state tax due on that gain as well. Each of the 3 children split up the $1 million, and each owed about $330,000 of tax on that gain. That tax, however, could have been fully avoided if Maurice still owned the item at the time of his death, because the item's market value would have been included in Maurice's assets for determining the amount, if any, of Maurice's estate subject to estate tax. The collectible and Maurice's other assets did not exceed the threshold that estate tax would have been levied on, and therefore 0 estate tax would have been due. Furthermore, no capital gains tax would have been owed by the children, because they would have inherited the collectible, which would have come to them with the market value included in the estate value calculation. This is what's commonly known as the step up in basis. So no estate tax would have been due and no income tax. The family didn't know these rules, and no one in the family ever sought estate planning advice. That's no planning. So an avoidable bad tax outcome. The second one, and I'm going to share it with you, is what I'm just going to call poor execution. Jan and her husband established a revocable trust in the 1980s. Their investment accounts, bank accounts, their house, they were all properly retitled into the name of the trust. And that way the trust could function as it was designed to. The trust directed that all of the trust assets upon the first of their deaths would pass to the survivor of the 2 of them. Upon the second of their deaths, remaining trust assets would pass out to their 3 sons, per stirpes. And per stirpes simply means If one of those sons was not alive, it would go to that son's children if there were any. In the 2010s, one of Jan's 3 sons died following a long period with chronic health issues, during which his spouse was extraordinarily supportive, loving and caring for her husband. And this couple had no children. Recognizing that her daughter-in-law would not receive any of her estate, Jan hired an attorney to draft a will to provide an outcome so that the daughter-in-law would receive 1/3 of her estate, the third that would have gone to the daughter-in-law's husband, Jan's son, if the son were living at the time of Jan's death. The problem was this. There was never any revoking of the living trust, and the assets that had been titled in the name of the trust were left in the name of the trust. So at Jan's death, there were essentially no assets in her name that would be subject to a probate proceeding that would be governed by the will. The trust was in effect, and essentially there were no estate assets to pass out. So Jan had all the best intentions, but between her and her attorney, terrible execution. Now, unfortunately, these things happen, and that's kind of the importance of estate planning. And it's a big part of what I do, is working with clients to understand what their objectives are. So I'm gonna take you through a few what we call fundamentals of estate planning. A lot of this is terminology. I'm going to go through this relatively quickly. Some of you may know this. We can circle back on it if you want more details. I'd kind of like to get through this and leave plenty of time for discussion and your questions. So when you are thinking about your estate plan, one of the first things I suggest people do is to basically create an inventory. You might think of it as a balance sheet. All of your accounts, how they are titled, whether they are owned by you individually, joint with someone else. Sometimes today people will use on their bank accounts and investment accounts designations such as transferable on death and payable on death. They may have in a residence or something like that, have a life estate. They may have set up trust, either under their wills or during use during their lives. And they could have other assets from business dealings, family, real estate dealings, and so forth, like what's listed here, a limited liability company. But I want you to think of that step simply as creating an inventory. So you make sure that you consider how all of the assets will pass to the people that you want them to pass to. So a few terms that I think is good to understand. You may come across these, particularly if you start doing your own research or talking to an estate attorney. And by the way, I want to emphasize, I am not an attorney. I'm trying to present this from the standpoint of practicality. I see what happens as the result of the estate plans. So it gives me some insights into the things that need to be considered when those plans are drafted. Terminology, intestate. It simply means that the person dies without a will. And there's no documentation for a judge to oversee and make sure that assets are passed out in accordance with the decedent's wishes. In that case, state law is used to decide where those assets are going to go. That is normally a bad outcome because normally the state laws are not going to replicate what the decedent's wishes would have been. Most of us probably have an idea of what a last will and testament is. It's an important document. The importance of that really depends on the overall estate planning structure. If somebody has, for example, a living trust, it may be less important, but you will always have one. Something I find is very helpful, very important, is letter of last instruction and other documents that are really designed to help the person or people administering the estate to know what the wishes of the decedent are. So I've seen this in various forms. Some have been actually very elaborately put together. And if somebody has in particular a rare item or items, collections, I'm thinking of a woman that had some very valuable quilts. She left instructions on how to dispose of those to the right organizations, the right people, either to sell them to maximize what they could get or as a charitable gift. I try to help people with those and encourage them to do it. They've been a big help to the people administering the estate to have those instructions. Another thing is taxes. I just want to touch a little bit on the taxes a little bit. And Ryan, back up, please. We should talk about this a little bit too. All the estate planning isn't worth much if nobody can find the will and the trust and the different things like that. It's important to entrust someone to know where you keep information. How do they find this? The emergency contact information. But in the last 10 or 20 years, a common problem has been that people are doing online banking and such. They die and nobody knows how the heck to get into the accounts. They don't have the passwords. So that's another one to make sure somebody knows where those are and can access your accounts so they can continue the financial affairs being properly managed. If you're a pet owner, your pet can't wait a week or a month for somebody to decide what's going to happen to it. Leave some instructions of what should happen. So these things that I would just encourage you to think about, including at the end the funeral instructions. My parents really did a great favor to myself and my two brothers. They had all their funeral planned out, including things like music at the church and things like that. Huge help. So these things, although they're not really legal documents, they are really good documents to have. So taxes gets confusing to people. There's two types of taxes that have to do with estates. Estate tax. That is tax paid by the estate on the value of the estate. And for most people today, under federal law, and frankly, under most state laws, they don't pay estate tax because it's almost $13 million of our assets that would be excluded from estate taxation. And for a married couple, that's about $26 million that gets excluded. The state levels are lower than that, but they're fairly substantial, still more like $6 million a piece as a round number. Also, a estate often will file an estate income tax return. That is simply income, usually dividends, interest, maybe collected rents, things like that, earned by the estate during that period of time that the assets are held by the estate. That tax return is much like a personal tax return, which we all know is the Form 1040, and for an estate, it's the Form 1041. So it gets confusing. People don't understand there's really two types of taxes to consider there. Trust. So trusts come in different forms. One of the real common ones is today our living trust. They are set up to be essentially a surrogate for your will and also for your power of attorney. Assets get retitled, they get put into the name of the trust, and upon death, the trustee, not the executor, is in charge of passing out those assets in accordance with the trust terms. And essentially, the will has very little impact. They're popular because they can avoid the probate process. And the probate process is a public process. Court records and stuff are available. Some people think somehow that it may save estate taxation. It doesn't. It doesn't save a dime. The same assets owned by the revocable living trust are subject to estate taxation as if the decedent had owned them individually. Sometimes people will use during life irrevocable trust. What they're doing here is they're transferring assets into a trust, giving up you basically control of those assets and not able to bring them back in for essentially estate planning purposes. This is usually people who are facing a potential taxable estate. We don't see a lot of those except for the wealthy. Testamentary trust are trusts created under the last will and testament of the decedent. These you may be familiar with, most commonly for younger people. And children or grandchildren or other relatives are going to receive money from an estate. And there's a fear or a concern the people receiving it may not be able to properly manage those assets, that they may squander them. So monies are directed by the will or by the revocable living trust to go into a trust for the benefit of the people that would be inheriting. And usually those monies are held in trust for the benefits of the people that the decedent wants, and they can be used for things like education, health, and other living expenses. But somebody's watching over those assets, the trustee, to make sure that they are not squandered. So these items, the will, the revocable living trust, irrevocable trust, they're all part of that estate planning. And which ones you need really is dependent upon each of your individual circumstances. I could get in deeply into these things and we'd use up all of our time. So I wanted to introduce them and we can circle back on those as well. I want to shift gears here a little bit away from what I would call pure estate planning to a couple of other very, very important documents. I often tell my clients when we talk about wills and other documents, I think a healthcare proxy very possibly may be the most important of all of them because it deals with things during our lives. Who are you going to entrust decisions about your health to? Maybe decisions that could make a difference between life and death. And I challenge people here not to think it's, a rite of passage. It has to be a spouse or the oldest child or whatever. Think about who's going to do the job. This can be emotionally difficult for people to fill that role. And you want somebody who's got the emotional fortitude to do it. And frankly, I think you might want someone who is going to take the time, if there is time, to be able to get second opinions and that type of thing. I don't want my healthcare proxy to just say, hey, doc, whatever you say. That's not what I'm looking for. And I don't think other people are either. That to me is a hugely important document. It deals with life, not just assets. And along with that is the living will. That's really what happens if you have a terminal condition. And it has to do with whether or not nutrition and hydration and life prolonging measures are given or withheld. I always disclose to people, I do not currently have a living will. I think I'm in good health. I hope to live a long time. And dang it, if something had happened to me yesterday, I'd hope they'd still be trying to keep me alive today. But when I'm 85, 90, 95, or 105, I may not feel that way. That's the role of that living will. And then the power of attorney. These are nice to have. I was the power of attorney for my parents. My mother, who had worked in a bank, she was one of the people that if you were having trouble like balancing your checkbook, she'd help people out with that. She was very financially savvy, but later in life, she just couldn't deal with these things anymore. They were too hard for her. She would get very frustrated. And I started taking over the routine bill paying, checking on insurances. I basically would go to their place at the desk and treat their finances as if they were my own. It was hugely helpful to them. And I encourage people to have those in place, because this is not just always for the elderly. Somebody could have a stroke or something like that and need somebody to step in and take over. And it kind of like the healthcare proxy, choose the right people that are organized, timely, and are going to get the job done. So that is admittedly kind of a quick run through. I wanted to at least get you thinking about some of the things that are typically considered as part of estate planning. A lot of what we have is just terminology. So when I throw out trust names and stuff like that, we can define that for you as much as you want or need. So with that, I'll open it up to your questions.
Thank you, Pete. Appreciate that thorough presentation and explaining the various aspects of a complete estate plan. So like I said, we'll move into the question and answer portion. We had some questions submitted ahead of time, so I'll start there. Just remember, you can submit questions live in our chat. So Pete, our first question, how do I include unborn grandchildren in my plan?
Now, that's commonly done. Attorneys know how to do this. And in essence, what they do is they don't reference the name of grandchildren, or if it's a young person, even children. They'll just make terms like all my living grandchildren, and reference them as a class of people. So it might say, if I want half of my estate to be divided among as many living grandchildren as I have at the time of my death. So it's very common. That's the way these things are usually written. When you come to dealing particularly with grandchildren, you usually do not name them. You instead have this kind of class of people, children, grandchildren, nieces, nephews, that are going to share in a portion or all of the estate.
Thank you. Our next question, what is the best way to make a planned gift to a charity, and how can I maximize my gift?
Well, it depends is the right answer here. This is something I spend a lot of time with, and I actually get a lot of satisfaction out of helping people with this. A lot of this comes down to objectives? What are you really trying to do? And there are various ways of doing it. So I think it's appropriate if we just say, what if I wanted to make a gift to Elmira College? How's the best way of doing that? Well, it depends a lot on circumstances. It could be something as simple as a cash gift. And if you're itemizing deductions on your tax return, taking a charitable deduction on your Schedule A itemized deductions. But that's becoming less frequent because the standard deductions are much higher and fewer people are now itemizing. So there are other methodologies that can be used. And I'm going to touch on these, and each could take quite a bit of time. So I won't get too far into the weeds on these. But for those people who are age 70 and a half or older, using a portion or maybe even all of the required distributions from their IRAs is a hugely tax efficient way to give to a charity. Those required distributions are taxable, but any portion of that up to $100,000 a year that is given directly to a charity is not taxed. So if a person was supposed to take $25,000 out of their IRA this year, because that's the minimum amount that they're required to, and they decided out of that $25,000 they were going to give $10,000 to Elmira College, they would only have to pay tax on the $15,000 they kept for themselves. So that's a very efficient way for those that are age 70 and a half or older to do that. Other times, if people have securities, usually stocks, that they've held for a while and have appreciated in value, you can give those securities directly to the charity. In our example, Elmira College. So let's say you wanted to give that same $10,000 gift to Elmira College. You could write a check and take a tax deduction for $10,000. Or you could give stock worth $10,000 and take this tax deduction. The difference is if you sold the stock, you'd pay capital gains tax on the gain. If you give that to the college or another charity, they sell it, you don't. They take the gain, and guess what their tax rate is? 0. So it's all the way around. You get the same benefit for the tax deduction and don't have to pay the capital gains tax. So that's something that's popular. And then there are other more sophisticated, and I don't want to scare you with that term, sophisticated ways to set up things like charitable remainder trust and charitable annuity trust. There are donor advised funds where you make large gifts and then pass that out to the charities you decide on over many years. So that's an area that I spend a lot of time in. If any of you have specific situations you want to review on that with me at some point, I'm glad to do that, just to have a discussion, no strings attached. Angela, you're muted.
Oh, I guess I was. I apologize. Thank you. So speaking of tax, we had a question come in from the chat. Is there a strategy for dealing with estate inheritance tax, as in Pennsylvania, for example?
Yeah, and that's different. Pennsylvania is one of a few states that doesn't just tax the estate assets, but they can and do tax the monies that the people receive from an estate. And the level of that taxation has to do with the relationship of the person receiving the money to the decedent. There are some strategies that are that are used there that basically revolve around trust. So sometimes getting money into trust so that they're not parts of a state, and there may be ways that that money can go out to the people that are intended to benefit without it being considered to be an inheritance. It's more of a trust distribution. It is an area that's really comes down, and I kind of said this earlier, knowing what your objectives are. So the short answer to that, there are ways of doing it, but without really knowing specific, it's hard to advise on it.
And that person's welcome to reach out to you personally. If they have any additional questions, we'd like to discuss it further.
Absolutely.
Another question. How often should I reassess my plan?
Well, if you have a life-changing event, you absolutely should do that. And that could be, the death of someone who's named in an estate plan already. It could be, a spouse, a child. That would be one reason. Sometimes family circumstances change. And I've had a few cases actually where people have come back and had wills that divided things up equally among their children. But life events don't always treat people equally or fairly. So people may say, you know what? One of my kids has really had a tough time. Their husband was ill, and it was expensive, and they lost income, and I really want to do more for that child. So they'll change it. Things like that, whenever there's an event that really would change the outcomes of those wills, you should quickly, I would suggest, understand how it's set up and take corrective actions if you want a different outcome. Even without that, as part of the way we're proactive with clients, we usually bring that up at a minimum every 5 years, and frankly, more often than not, about every 3 years. A lot of times we spend a little bit of time going through it. People say, nope, it's good, no changes, and we move on. But sometimes a change could be as simple as, and I just had this as now that I think about it, someone who had decided the person they named as their executor was no longer in a life position that they should have to deal with something like an estate. They had some problems in their own family, and they said, you know what, we got to change that. It's not the right person to ask to do that job. So that's why I think looking at it every once in a while, you may not go back to an attorney, but on your own with help, just reviewing it, making sure that everything that's there is still appropriate.
Thank you. Next question. What if my assets are jointly owned by a non-spouse?
Well, if assets are jointly owned with a spouse or otherwise, those assets will pass to the person named on that account automatically. So I'll give you a hypothetical. So suppose somebody had a bank account, and we're just going to call it Joe and Jolene's bank account. And in their will, it says Joe and Jolene's bank account is supposed to go to cousin Eddie. And Joe or Jolene die. It's not going to go to cousin Eddie. It's going to go to the survivor of the two of them automatically. It's not a probate asset. The will has nothing to do with it. It passes to the survivor by operation of law. And people get tripped up on this sometimes. So it's very important that when you have an estate plan, that you consider how all of the assets are titled so that the estate plan will function as intended. It's kind of like that second example I went through, where the woman had all these assets in her trust and had a will that frankly was useless because she had no assets outside the trust. So you got to make sure that if it is jointly held, that is where you want the money to go. A very, very frequent thing I see is where a child will be listed on a bank account with a parent or parents. And that's a convenience factor. It's so they can help pay bills and things like that. But it's important to realize that legally, upon the death of the parent or parents, the one child name legally owns that account.
Yeah. We have another question coming in the chat. Do all changes to a will have to go through a lawyer, or can they be added with a notarized signature to be included in the will?
Well, legally, a will does not have to be done by an attorney. You've probably heard the term of deathbed wills, where somebody just kind of writes something out by hand, gets it witnessed and notarized. Usually the witnesses are notarized too. That should be legally enforceable. But there are all types of opportunities for that good intended will to fail. So without reservation, I always tell people, spend the money to get it done right. Now, today, there's a lot of online services where LegalZoom.com and that type of thing. And those wills are acceptable in most states. And I suppose there's nothing wrong with them for somebody who has a simple will. The will might say, if I die, everything to my spouse. If my spouse is already deceased, divide it up among my 2 children. That may be perfectly okay. But even with that, a lot of times a good estate planning attorney will bring up ideas that are worth paying for. I may bring up ideas, but they'll have hopefully other ones even beyond what I might think of. So the answer is yes, you can write them out by hand. It's probably okay if you don't have much other choice. For example, you are getting ready to travel overseas, you don't have a will at all, and that's better than nothing. But long term, I'd suggest you use an attorney.
Thank you. Next question. How long does it take to complete an estate plan?
That's another, it depends on the complexities. Now, this is another good story. I once had an estate plan that took over 2 years. I've been 3 years. It was all done, except for one item that the couple could not decide upon. And it was silly, absolutely silly. They had collected a whole bunch of New York Yankee memorabilia, and they could not agree for 2+ years of what should happen to that memorabilia. It was, for me, honestly, it was tremendously frustrating because it was like, who cares really at the end of the day? There were other things. So there are things like that. And then if there's complex estate planning where there might be trusts that have to be set up, assets to get moved around and retitled, it could take months just because of that. But I have seen people come in one time, we get things down on paper what they want, they go to an attorney, and 3 or 4 weeks later it's done. So it does depend. Angela, you're muted again.
That's a sticky mute button. Okay, let's try this again. My apologies. Can you tell me about the gift tax and its filing requirements?
Yes. A lot of people don't know about it and they don't file. So each of us is allowed every year to give money to as many different people that we want, as long as it does not exceed the annual gift limits per person. And that today is $16,000.
Yeah.
So if I wanted to give one of my two daughters $16,000, I could do that. There's no gift tax return filing requirements. I'm within the limit. If I wanted to give each of my two daughters $16,000, there's no gift tax return requirement. This gets better. If my wife wanted to do the same thing, we could collectively give $32,000 to each of our two daughters. No gift tax return needed, as long as that came from joint assets. And you can do that to as many different people as you want. But here's what happens. Let's suppose, for whatever reason, I wanted to give one of my daughters $20,000 from my assets and nothing from my wife's assets. Well, it exceeds $16,000 by $4,000. So technically, what one should do is file for that year a gift tax return. And what it does is it says, I gave away $20,000. I used up 16 on my annual exclusion amount. And the $4,000 is going to come off my lifetime exclusion, which is over and above the annual exclusions. And that amount today is about $13 million, roughly. It's a little under that. So now you file this return and it says, instead of $13 million left, I only have $12,996,000 left to give away during my life or at my death. And my response to that would be, who cares? File the friggin' return. There's no tax due. Get it on record. And if you end up with a taxable estate because you've given away $13 million, good for you.
Thanks, Pete. We have time for one more question. And this one comes from the chat. What are the costs, understanding that it's dependent on an individual basis? Can you estimate the costs associated with the development of an estate plan?
Again, it depends, the complexities. If somebody's doing kind of a simple package where they might just have a will that might or might not include testamentary trust in the will, do a power of attorney, a healthcare proxy, those can run, maybe $1,500 to or more, depending on the law firm. If it's a very complex estate, you're going to go to a more knowledgeable firm, quite frankly, usually a bigger firm that has people that are highly specialized in this. And I've seen those plans cost $5,000-$6,000. Sounds like a lot of money, but if somebody is dealing with a taxable estate, which would be over $12 million, the estate tax cost of those are very high, and having the right documents in place can save way more, multiples of what those legal fees would be. So it depends, but I would say if it's a relatively simple one, you probably, all of those documents, time with the attorney, the paralegals doing their work, maybe $1,500 to $2,500 is my guess.
Perfect. Thank you. I think Dr. Lindsay had a few words he wants to say before we close.
Yeah, first, I'd like to thank Pete for the time you spent today. Really appreciate the depth and breadth of your knowledge, and it was really a great primer on estate planning. So thank you.
You're welcome.
And to all of you who were listening in, I hope you found this workshop informative and that it'll help you as you begin to think about your financial wellness and plans for the future. So one plug, if you're thinking about those plans, I hope that you're able to connect with situations, people, or institutions that really stir your passion. You can make a charitable bequest that'll help advance your passion and make a difference in other people's lives. And if EC is one of those places, just to mention one randomly, I want you to please feel free to reach out to Angela. She'd be happy to discuss how to carry out your legacy and make a difference in the lives of EC students today. So thanks again, and I'll pass it back to Angela for some housekeeping information.
Thank you, Dr. Lindsay. So if you'd like to reach out to Pete directly, we will share his contact information in the chat. Again, the recording will be available on our alumni YouTube channel. And finally, in a few days, you'll receive an email survey from us. It's just a few questions that would provide important feedback on today's workshop and help us improve the process for next time. So again, thank you, Pete, John G. Ullman Associates, for your time today and providing us with this helpful information. So with that, have a terrific day and thanks again.
Nice to be with you all. Thank you.
Thank you.